In October 2018, an anti-affirmative action coalition called Students for Fair Admissions filed a lawsuit against Harvard University for discriminating against Asian American applicants on the basis of race. What ensued from the case and the precedents upon which it is based can only be described as a maelstrom of anti-diversity rhetoric and a virtual policy coup by conservative groups attempting to reforge the NAACP's 1950s formula of using litigation to overturn segregation to now overturn the affirmative action-based policy decisions of those very same suits. In order to discuss this case, it's important to understand exactly what affirmative action is, how and why it came to be, and its relevance to this day. In its most basic form, and as defined by Gale Encyclopedia, affirmative action is a series of programs designed to help traditionally disadvantaged populations. The principal tenet of affirmative action policy is to uplift formerly disenfranchised, disregarded, or disadvantaged groups by offering members of minority populations, including women, preferential treatment in selection processes for college admissions, career hirings, etc. Essentially, in the case of two otherwise equally qualified candidates, preference is given to the one from the previously disregarded minority group. Defined so broadly, questions in opposition to affirmative action are guaranteed to surface. The central argument against affirmative action is that it naturally discriminates against white men, which in essence works counter to the goal of equality and equity pro-affirmative action policymakers allege to aspire toward. It's important, however, to consider affirmative action's complicated history in the mid to late 20th century. The policy arose amid the wave of progressive anti-discriminatory legislation that cemented an end to the Jim Crow South's dream of secession. The Supreme Court's anti-segregation decision in Brown v. Board and the passage of the Voting Rights Act of 1964, not to mention the subtle but sweeping litigative victories strategized by the NAACP and prominent leaders of the civil rights movement such as Martin Luther King Jr. or Presidents Kennedy and Lyndon Johnson, aimed to finally and fully quash the discriminatory practices in education and employment which plagued America's history. Ever since its implementation, affirmative action was intended as a temporary policy, only to be carried out insofar as to correct the wrongs of the past and reach a state of equality and multiculturalism in the United States. And for a while, the policies worked. In a comparative study between the 1999 to 2000 school year and the 2009 to 2010 school year, Black and Hispanic rates of graduation more than doubled. In 2011, the Bureau of Labor Statistics reported that Asian American men and women were earning more than their white counterparts. By 2012, women made up 46.9% of the workforce, and they held roughly 51.5% of managerial or professional positions. Affirmative action policies actually succeeded in their goal of reversing generations of discrimination and helped pave the way toward a more tolerant and accessible society. Children who grew up in the era of affirmative action were more likely to be successful in engaging with global business markets than workers from prior generations, and students who attended post-secondary institutions which practiced affirmative action were far more likely to be culturally conscious, respectful, and inclusive of people outside their race or ethnic group than uneducated Americans. The benefits of affirmative action were obvious and indisputable. Unfortunately, although discriminatory practices in education and employment may have disappeared overnight, discriminatory sentiments had not. Some policymakers ultimately decided that temporary affirmative action policies had reached their termination date since the United States had evidently reached its goal of becoming a rainbow-colored meritocracy, and when affirmative action policies were slowly and silently repealed, the immediate impacts were astounding. A University of Michigan study found that after affirmative action programs were outlawed in Texas in 1995, the University of Texas Law School Latino student enrollment was cut in half. In the 2010 to 2011 school year, less than 40% of all MBAs earned went to women. The amount of female faculty in the UC system has decreased by 22% since their repeal of affirmative action policies, and throughout the 21st century, minorities are considerably overrepresented in the unemployment rate compared to their white counterparts, even though minorities, by definition, constitute a much smaller percentage of the population. The effects of an absence of affirmative action policies highlight the necessity of these policies, even as America moves away from the redefining cultural and political movements of the 60s into what we perceive as a more forward-thinking society. However, despite overwhelming evidence to the contrary, many still question the validity of affirmative action as an anti-discriminatory policy, given its inherent discrimination against white men. During her time at Harvard University, Sarah Siskind wrote an op-ed in Harvard's school newspaper vehemently denouncing the decision of Fisher v. University of Texas, a Supreme Court case surrounding Abigail Fisher, a white University of Texas applicant who was denied acceptance to the university and who argued the decision was made on the basis of race. Siskin's ultimate thesis is that institutions should not need to lower their academic standards simply to promote higher racial diversity. However, perhaps Siskin should have more closely examined Fisher's case, which, with the help of conservative anti-affirmative attorney Edward Bloom, went all the way to the Supreme Court twice, only to be struck down both times. In a ProPublica article, journalist Nicole Hannah-Jones delineates the history of discrimination suits in the Supreme Court, beginning in the Jim Crow era and leading up to modern-day backlash from primarily conservative groups who have turned the doctrine of a colorblind constitution on its head to now argue that affirmative action policies are inherently discriminatory due to selection based on race. Hannah-Jones counters this sentiment, declaring that politically driven cases are endorsed solely by Southern segregationist sympathizers and only seek to undo the progress that decades of affirmative action have attempted to promote. All this brings us back to the modern day in the case of Students for Fair Admissions v. Harvard. SFFA is Edward Bloom's newest passion project and his latest attempt to overturn affirmative action at the highest levels of American government. This time, he's recast the lead of his keynote case as a group of disgruntled Asian American students to take advantage of one minority group in an effort to disadvantage all minority groups. American proponents of freedom of accessibility to advancement and opportunity need to acknowledge the necessities of affirmative action programs, especially at higher education institutions of significant caliber like Harvard, in order to combat efforts currently at play to undo the decades of positive progress we've made in this country. In the words of Tiffany Jones, Director of Higher Education Policy at the Education Trust, it matters a lot what the Harvards of the world do. Affirmative action serves primarily to promote racial and socioeconomic diversity in education and to provide marginalized and underserved groups opportunities which they may otherwise have never have received, despite being fully qualified and due almost exclusively to extenuating circumstances such as finances or lack of availability for personal growth opportunities. Affirmative action is important for societies interested in ending long-standing racial hierarchies and bolstering opportunities for advancement in underserved communities.